You're still under oath, Mr. Van Zyl?
I do, ma'am.
Thank you very much. Yes, Mr. Nel.
May it please the court, my lady. Mr. Van Zyl, yesterday you gave evidence about what you knew about the relationship between the accused and the deceased Reeva Steenkamp in this matter.
That is correct.
I asked you questions about what you knew about the relationship between the accused and somebody's passport or a girlfriend's passport if he didn't want you to arrange a trip. Am I right?
I would receive passports when we had to do visas for specific trips.
And that's athletic trips.
For athletic trips or for whenever we had to go abroad and we required visas for that specific country.
Did you ever go across, did you go overseas with Samantha Taylor?
I never went overseas with Ms.
Did you
Taylor.
ever have to arrange a visa for her?
I cannot recall that I had to arrange a visa for Ms. Taylor.
If I put to you that you received an email from the accused sending you a copy of Samantha Taylor's passport, and that happened on the 12th of September 2012. Would that be strange?
I can honestly not recall that email that I received.
You see, I don't want to read out your email address, so I'd rather send you a document just to check if you can identify your email address, and I will just indicate with an arrow where I would want you to look. I know you're reading everything now, but there's an arrow indicating your email address, am I right?
That's correct.
And I see you've already turned the page, then you're welcome to. You see there's a scanned in copy of a passport.
That's correct, sir.
And a message to you. You see that?
I see that there's a message
To you.
to me.
And on reading it, it's from Oz.
That is correct.
And who's Oz?
That is Mr. Pistorius' name that we sometimes used to call him.
So can you still remember having received that email?
I must admit I cannot recall receiving this email, but I obviously did receive this email.
Now, why would you receive an email? Let me just hand it in. Lady, this will be XXX. There will be more than one, lady. May I beg leave to hand this in as XXX1, lady. Now, let us just read out what the accused, or in terms of what we have in front of us, what the message was. Will you read it up?
Which message, sir?
The one underneath the scanned copy of the passport.
With page 2.
Page 2 of 3.
Hi, Pierre. Here is Sam's passport. Please keep it on file. Think we're sorting shit out. Oz.
Now let's deal with sorting shit out. What is that?
If I have to read this as it is here and interpret it, I would assume it would be a love quarrel or difference of opinion that they might have had.
But then if he writes you something like that, he must think you know what's going on. Otherwise, why would he say that?
I must admit I did not interfere in any of Mr. Pistorius or any of my other clients' personal lives, and I did not ask what he specifically referred to here in this case.
No, that, you see, you're not answering it. I'm not saying you asked. I'm not saying you interfered. I said, for somebody to write that to you, that person must think you know what's going on. Because he's saying, please keep it on file, think we're sorting shit out. So he must think you know what's going on, otherwise he won't write that.
If I can honestly say, I did not know what was going on, and if there was something wrong, something specifically wrong, sir.
So what did you do with the passport? He now sent you this. What was the purpose of it?
I kept this passport on file for a later occasion when Ms. Taylor accompanied Mr. Pistorius for a television production that was happening on the Seychelles later that year. That she accompanied him, Mr. Pistorius, to this trip.
So you arranged that?
No, I didn't arrange it. We were approached by a television production company that wanted Mr. Pistorius to be a guest on this show, and they offered a trip to the Seychelles for Mr. Pistorius and a person that he could take along with.
Mr. Van Zyl, did you arrange the tickets or anything? That's my question.
I then had to give all the information through to the television production company, and as far as I could recall, they then arranged the flight.
So what you're saying is, as a fact, the Mauritius trip happened after September.
It was
After
the
Seychelles.
It was the Seychelles.
It happened
trip.
after September 2012.
As far as I can recall, I don't have the specific dates of that trip, but it was definitely after the season was finished.
Okay. Now, let's deal with.
As I said, I can't recall. The only communication I had at that stage was from Coach Ampilo, who's also Mr. Pistorius' personal coach and was also one of the team coaches of Team South Africa, who phoned me to inform me that there was an issue with one of the athletes and Mr. Pistorius, but it has been taken care of and sorted, as it was called, by the team management.
You took no further steps?
As far as I can recall, no.
Now, I'm going to send you across an article by Mr. David O'Sullivan. Ask you if you ever read this.
This specific article I have not read.
If not?
No.
Okay. I'm just going to then deal with certain aspects of this article to ask you if you know about this. Lady, seeing I'm referring to this, I'll hand this in. XXX2, lady. In paragraph Paragraph 4, if you just number the paragraphs yourself, it starts with, still I was aware this poster boy for the Paralympic Games could have flashes of a darker side. I had experienced this anger shortly before the Beijing Paralympic Games. Oscar was at the pre-games training camp and phoned Mr. O'Sullivan, raging about what he perceived to be inadequate training kit. His fury at the South African management caught me by surprise. Oscar knew he couldn't be ignored, and his anger would ensure his demands were met. I hadn't expected Oscar to be a prima donna. Do you know anything about the accused unhappiness about this?
I was aware of the training kit being insufficient that was supplied to the Paralympic team at that stage.
And he was upset about it.
And that Mr. Pistorius was upset about it.
And so what did he do? You knew that he was upset.
I knew that he was upset.
So what happened?
But as far as I can recall, I wasn't at Beijing at the Paralympic Games. I also wasn't at the training camp. And just to clarify that once an athlete is part of Team South Africa, whether it be to a training camp or during a competition like the Olympics, Paralympics or Commonwealth Games, Team South Africa takes preference and they take over these athletes. Then I have very little access to any of my athletes.
But you manage the athlete. You manage his profile, you manage his life as far as the athlete's concerned. If something like that happens, you get involved. Even if you have to mitigate a fallout, or don't you?
When, again, I stated, as when an athlete is part of Team South Africa, I have very little access to any of my athletes. And Team South Africa's team management, team leader, their press officer, coaches, team coaches, they take care of any of these events. It's often a situation where I would get information secondhand then, after it's happened.
Okay. Then the next paragraph, paragraph 5, I'm not going to read the whole paragraph, but if you could follow where he said, second last line, he told me he had been forced to move out because Oscar was constantly screaming in anger at people on the phone. I thought he was joking and waited for a smile, but he was serious. So you never heard that he was constantly screaming in anger at people on the phone?
I never heard that. As per my answer yesterday, I received a phone call from Coach Ampilo informing me that there was an issue with one of the athletes, and that team management will take care of this and they will sort it out. I didn't really take any further notice of this, as I was really swamped with a lot of other requests and sponsorship engagements for Mr. Pistorius post-London. I can also add that subsequently to this, that there was a statement released by Mr. Arno Fourie, who is the athlete in question here, last night on his Twitter account.
Good, I'm so glad you mentioned that. Because that brings me to two questions. Did anybody discuss your evidence with you since you left court yesterday?
Nobody has discussed any evidence with me, my lady. I received an email from some of my friends overseas who follows all these athletes, and they pointed out to me that this was on Mr. Arno Fourie's Twitter account.
But then you would also know that he never denied the fact that the calls were made. You mentioned it. You mentioned it, Mr. Van Zyl. You read it. He never denied the fact
That's correct, my lady. Mr. Fourie did not deny that there wasn't calls made, but from what I could gather, as I said, I was informed that there was an incident between Mr. Pistorius and another athlete, and that it was taken care of by the team management.
But now we at your comeback. Your comeback was, I have to tell the court that there was a withdrawal of this last night. We're there. Let's deal with that. Nowhere in Mr. Arno Fourie's tweet of last night did he deny the fact that Oscar was on the phone screaming at people. Am I right?
That is correct.
Okay. Then will you be surprised if I say that the accused wrote a letter to Samantha Taylor wherein he said, I invited you to London because I knew that without me knowing you have had my heart in your hands for months and never once let it go. He said he invited her to London. Why would you not know that?
Because I was never informed of that as far as I can recall.
Did you not phone Samantha's mother to try and get them to London? Because that's also what I have. Think about it, please, Mr. Van Zyl.
I can honestly state that I cannot recall having to arrange for Ms. Taylor to go to the London Olympic Games.
You see, because the point you made is he's the first girl ever he's invited, and now I sit with a letter written by him, which shows the contrary. Let me show you. Malay, may this behind it is XXX3.
Did you say 3?
3, Malay. Now, it's a long letter. It might become relevant and later with other witnesses. But let us just go to page 4, please. Will you follow? It's in the first paragraph. I'm not reading the whole paragraph. So I don't think that's necessary. It's line 8 from the top. Will you follow with me, please? That was not fair on you, as you have never given me a reason to mistrust you, and you've only been everything I could ever want. This is so hard to write because I don't deserve you, Sam. When I invited you, I was so excited to tell you because I knew we had some hard days behind us. I had asked Piet to do everything he could last week to find you a ticket. So that's not true. That Piet must be you.
It's me, but I can honestly not recall that I had to find or source or secure a ticket.
But let's unpack that. If he asked you to arrange a ticket for Samantha Taylor, you would have remembered. This must then be a lie that he wrote.
I cannot say if it's a lie that he wrote because, as I said, I cannot recall having to source or secure a ticket for Ms. Taylor to the Olympics.
Okay, let us just take one question at a time. If he asked you, you would have remembered.
Probably. I cannot recall.
Okay. Then you just go to the next paragraph. The last 3 lines. Will you follow with me, please? I don't even feel like going to London now that you won't be there with me. I don't know how I let it go this far, but I'll never forgive myself for not looking after your heart that you place in my hands. So he's referring to, if he says, I don't feel like going to London, what is he referring to?
He must be referring to the London, either Olympic Games or Paralympic Games.
Yes. So, still you're saying that you never knew that he wanted her to go?
As I stated, as far as I can recall, I cannot recall that I was specifically asked to find or source or secure a ticket for Ms. Taylor to the Olympic Games.
I'm going to read. I don't want to go through. If one goes through this whole letter, it's significant. It indicates that, as far as he was concerned, he was in love with Samantha. You never knew that, or did you?
No, I knew. As I stated earlier, I knew that he was in love with Ms. Taylor because on the few occasions that I did meet the two together, it was to me a normal, loving relationship.
And when was the London Olympics?
August, as far as I can recall, 2012.
Okay, the last portion is then in the next paragraph. Well, I'm going to read as it's here. Will you follow? It's the fourth last line. It took me a long time to be honest with myself and to truly fall in love with you, Sam. At least I know it wasn't forced. It wasn't a figure of my imagination. I invited you to London because I know that without me knowing you have had my heart in your hands for months and never once let it go. So, I mean, the regular references to this invitation, and you didn't know about it. Why would you not know about it?
As I said, I cannot recall.
Or it's just important for you to say that he invited one person and that was Reeva. Because why would you not be able to recall this?
As I stated earlier, my lady, I cannot recall to an athletics competition that Mr. Pistorius invited anybody else than Ms. Steenkamp. For instance, we also had Miss Jenna Atkins, which was one of Mr. Pistorius' previous girlfriends, where we had to arrange for her to join him, but that was for a photo shoot for a publication in Italy.
You're right. Just go to page 30. The last paragraph. I invited Jenna over last year for a week to Jamona, but after the night she went out with her friends, I cancelled the trip because I didn't want to be emotionally, well, it's venerable before world champs. So is that what you're referring to?
No, my lady. I think this must be Mr. Pistorius wanting to invite Miss Atkins to Jamona. Miss Atkins accompanied us to Milan for a specific trip where it was scheduled that Mr. Pistorius and his then girlfriend had to do a photo shoot for a fashion magazine.
So it happened, that trip?
That trip happened, yes.
And this one that Mr. Pistorius wrote about, the accused, you don't know anything about this?
No.
Now, just after the incident, you were able to visit the accused at the Brooklyn police station.
I saw Mr. Pistorius at the Brooklyn police cells on, as I can recall, I think the Sunday after the incident occurred.
Yes, on the 17th of February. It's the 17th of February. Take it from me. I'm not allowed to give you dates that's not so. Okay. Now, when you came out, there was a televised media statement by you.
That's correct.
You followed that up with a formal statement.
That's correct.
That you posted on a Facebook website.
I don't have a Facebook website, but either the publicist that we use must have then posted it on a Facebook website. I wasn't aware that it was on a Facebook website. As far as I can recall, the only places we did is we circulated to a media list and then also posted it on my own website, my business website.
Okay. Now, you also had a media interview with a radio station called Balls, B-A-L-L-Z.
That, as far as I can recall, is Mr. Darren Scott.
No, but you had an interview with that radio station. That's on correct. The 18th of February. That lasted about 10 minutes.
That's correct.
You can still recall what you said in your media releases and statements and during the radio interview?
I would have to be honest that I cannot recall everything that I've said, but basically it was relating to the sponsorship and endorsement deals that we had to either suspend, terminate, cancel, and also that all competitions that Mr. Pistorius was scheduled to compete in for 2013 I had to cancel.
You're right. But there were more. There were things like he received support on a global scale.
That is also correct. On his website, we would receive messages from all over the world, and we would then process that. I had someone specifically taking care of that for me.
And that you were there in your official as his manager and as his friend, and that you support Mr. Pistorius.
I was there in my capacity as his manager and also as his friend to give him my moral support for going through this traumatic period.
But you never once sent him there, sent the condolences to the Steenkamp family or anything like that in any of your media releases then?
I made mention, and in my personal and also business capacity, we had sent a bouquet of flowers to the Steenkamp family.
Is that all? But when the people asked you on international TV and in your official statement, you never said anything. But you want us to know, and we write it down. We send a bouquet of flowers. Is that all?
I am not quite following the question.
You had an opportunity to commiserate with the Steenkamp family, to send your condolences, but you didn't. Not on the 17th or the 18th.
Based on advice, I was informed not to make any contact with family. That's why we did not act out on anything.
No. I never asked you to make contact. I asked you as a person, as a friend of Reeva's, that you want this court to believe. Why did you not do that?
I did not want to make the court believe, my lady, that I am a friend of Reeva. I have met Ms. Reeva Steenkamp on a few occasions and was introduced to me as Mr. Pistorius' girlfriend. I never became friends with any of Mr. Pistorius' previous girlfriends, only introduced and had a few occasions where I met them from time to time at social events where Mr. Pistorius had either sponsors obligations or things similar to that.
Okay, I'll move on to the next point. You related an incident in an airplane, the incident with the stewardess and the prosthesis. What point did you make there?
Basically, that Mr. Pistorius was uncomfortable with the fact that people had to see him without his legs in public, without his prosthetics in public.
If I tell you that it was also published that whilst on holiday, he left his prosthesis on a beach, and that was not a problem. See, I don't want to go there, but that's the point you made.
I can only testify to what I personally experienced with Mr. Pistorius in certain instances, and that was the instance where this leg was lying in the aisle of the plane, and he was very concerned that someone saw the leg and made sure that he covered the leg.
But you would then, if I show you a photograph on a holiday at a beach, you would just leave his prosthesis on the beach. Will you be surprised?
I will, because I've never seen that photograph.
You're welcome to. You want to tell me you've never seen that photograph? Did you not follow the media post this incident?
No, I did not. And I deliberately did not, because of the traumatic experience it was for me, where I was busy planning all these events for Ms. Steenkamp and Mr. Pistorius together in a matter of even hours before the incident happened. And I refer to the email that I sent that evening of the 13th of February. That was why I also never was following any media.
I find that interesting, that you're still the manager. You have to manage the fallout. You have to manage future contracts, future engagements. You have to, and you want to tell the court that you did not follow what's going on in the media.
My lady, I do not have any future contracts or anything of that sort to matter, as contracts have been terminated. So much so also that we had to sign documents of Mr. Pistorius having to pay monies back to some of his sponsors that he received.
I beg leave to hand that in XXX form.
Thus, I don't stand to gain anything by being biased towards Mr. Pistorius in my testimony.
You see, I didn't want to, but I have to know everything you said. I have to look at. You said that the accused and Reeva will call each other pet names. Is that what you said?
In front of me, the few occasions that I did meet them, they did call each other pet names.
Do you know if they had a pet name for Samantha?
I cannot recall the pet name for Ms. Taylor.
Have you heard Little Butterfly?
No, I have not heard that name called to Ms. Taylor.
Cannot deny the fact that he called her his Little Butterfly.
I cannot deny the fact, but I have never heard him call that in front of me.
Now, if I put to you, and I don't want to, I can show you lots of other things that would indicate that Mr. Pistorius wanted a very serious relationship with Sam Taylor, said so on lots of occasions, that she's the one girl in the world for him. Why would you not know that that relationship was so strong between him and Sam Taylor?
Because I wasn't part of Mr. Pistorius' private life.
Can I ask you so? But also not with Reeva.
Same with Ms. Steenkamp. As I said, I met them on various occasions.
So the relationship could have been the same then as with Sam?
For me, in my opinion, the relationship that I had or the three persons that Mr. Pistorius has ever introduced me as his girlfriends, he was always loving with them, treated them kindly, affectionate towards them. So I would assume, and the fact that he had these relationships over extended periods of time showed to me that he was serious in these relationships.
Yeah. All three of them, so that would be Jenna, Sam Taylor and Reeva. It's the same thing as far as you're concerned.
Definitely.
Yeah. That's fine. As far as can I ask you, do you know of injury the accused sustained since the incident?
Mr. Nell, just take a seat. What is going on?
Your Worship, it's
No, Mr.
I
Nell.
was no surprise, my lady.
Mr. Nell, please take a seat.
Okay.
What is going on?
A device went off.
Pardon?
A device went off accidentally.
Okay. You know, you are an officer of court, aren't you?
Pardon?
Are you an officer of court? You're not?
I'm an expert.
I see. Okay. So that's why Mr. Nell had to stand up. But, you know, when something like that happens, you just stand up and apologize immediately. You don't wait for the court to do a witch hunting.
I apologize.
Okay. Thank you.
And also from our side, it's an apology. I'm sure it went off by mistake.
It did, I'm sure of it.
But it is so... Do you know of an injury sustained by the accused in a motor vehicle accident?
No, I'm not aware of any injuries that Mr. Pistorius sustained in a motor vehicle accident.
He was involved in an incident where a car rolled. Now, it's since the incident to today.
Since after the 14th of February 2013? Yeah. No, I'm not aware of it.
Do you know of any other incidents where a car rolled?
No, I'm not aware of that.
Nobody discussed with you?
No one discussed with me any vehicle accidents that Mr. Pistorius was involved.
You don't know of anything about a rally vehicle that Mr. Pistorius was in?
None whatsoever.
Right, I will carry on now. Another instance of aggressive behavior, I've been informed, happened when the accused was left out the final of the 4x4 meter relay, 4x400 meter relay. He was very upset about that, and he kicked chairs and things at a team meeting. Do you know anything about that?
I am aware of the fact that Mr. Pistorius was left out for the final for the 4x400 meter relay men at the World Championships in Daegu in South Korea 2011, and that he was unhappy. But again, as I said, I wasn't in any of those meetings. It was part of the Team South Africa meetings.
I know you weren't part of the meeting. I know you weren't there. But did you at least
I
heard about it?
I heard about it, but I wasn't aware that chairs was kicked. For instance, that
you heard about it from
team coaches, that Mr. Pistorius was unhappy for the fact that, and then I also met with him later that day when he informed me that he was not part of the team or the squad for the final for the relay.
Now, as far as you sitting where you're sitting is concerned, how did he express his anger?
He was actually more disheartened and almost in tears that he couldn't run in the final when I saw him.
But you weren't there when it happened.
I weren't there in the team meeting when it happened, so I don't know if he was aggressive or not aggressive. But when he informed me of the incident that he's left out of the squad, my lady, as I stated, he was almost in tears, crying for not being able to help to contribute to the South African team, where they have set a new South African record in the heats in the previous day.
It must be some drilling or something going on.
I hope it's only drilling.
Same here, my lady. I've convinced myself it must be drilling because something is happening.
Yes, I think one of the police officers went out to find out what's going on.
I think the registrar has some idea where. Okay. No, my lady, it's roadworks.
Okay. Oh, roadworks.
Yes.
Oh. I was hoping it was in the building so we could do something about it.
Yeah, we'll be able to do something.
Yeah.
Then lastly, No, I'm not going there. Well, I have no further questions.
Thank you very much. Yes, Mr. Roo.
Thank you, my lady. Maybe just for completeness, you referred to the Twitter that you received.
That's correct, my lady.
Can you just identify it? I think it would be appropriate to follow the XXX numbers. The last one I think was XXX4. So if you could accept this as XXX5, my lady. It is just merely because there was reference to it.
Yes.
Can you just read it? Is this the Twitter that you refer to?
This is the Twitter I refer to.
Just read it.
It was posted on the 1st of July 2014, 23:59. Just to clarify, I approached our medical doctor at the London 2012 Paralympic Games to find out if the isolation room was available 2 nights before our 100-meter final. It was one of the most important races of my life, and I wanted to rest and recover well on my own time in preparation for the race. I cherish all the moments we shared at the London Games. Arno Fourie.
I have no further re-examination. Thank you.
Do you have any questions? Mr. Fansel, thank you very much for your assistance. You may be excused.
Marie.
My lady, I made reference to a photo that we wanted to hand up as an exhibit. It is purely, my lady, to show a time of the arrival of the Netcare 911, the paramedics at the Silverwoods estate at the time of 3:41:50. I asked the court to accept that as exhibit YYY, my lady. If I may say, we do this because we will attempt in the heads of argument ultimately to, through objective evidence, to try and give you times when events took place, and we realize that we did not have the time of the, because none of the paramedics were called the exact time of the arrival of the ambulance.
Okay, thank
at
you.
3:41 at the gate. Then, my lady, I spoke to Mr. Nell. I believe his attitude would be the same, but we undertook to come back to you as regards the reports ordered by you. I think in the first place, just for housekeeping, it should be numbered. Mm-hmm. The psychiatrist report should, the next exhibit number would then be for the psychiatrist report as exhibit ZZZ. I understand it was in fact numbered, my lady. My mistake.
Yes.
RRR.
It must have been because it's already filed.
Yes, my lady.
Yes.
So then the second part is, my lady, and I discussed this with Mr. Nell, we said that we would give you our attitude. The attitude of defense is this, that it's a report, and I refer now to both the reports, the psychiatrist report and the psychologist report. It's a report requested by the court. Therefore, it's before the court.
Yes,
we, of course, have a right to ask the court to have cross-examination. Of course, if we don't exercise that right, it's not to say that you agree with everything. At the end of the day, we will argue, and it's for what we want to rely on, and the court will take into account the report. The court will take into account if there was no cross-examination as a factor, and the court will take into account whatever is stated in the report in the context of other evidence. So what we're saying, we're not saying that we accept as the truth everything, but we say that's the report, that's before we, there's no need to call the witness. I would just, for completeness sake, my lady, read at page 29, the evaluation, just to put that before the court. That's page 29 of the psychologist's report. It's a report that was commissioned by you, requested by you by Professor J.G. Scholes, dated 27 June 2014, and the background is there and all the tests done are there. It may be dealt with, I believe, in argument ultimately. And then the evaluation is page 29, and it says the following. From my assessment of Mr. Pistorius and with the information currently at my disposal, I come to the following conclusions. 5.1. Mr. Pistorius has been severely traumatized by the events that took place on the 14th of February 2014. He currently suffers from a post-traumatic stress disorder and a major depressive disorder as defined by Diagnostic and Statistical Manual 5 in brackets DSM-5, see Annexure C. The degree of anxiety and depression that is present is significant. He is also mourning the loss of Ms. Steenkamp. 5.2. Mr. Pistorius is being treated and should continue to receive clinical care by a psychiatrist and a clinical psychologist for his current condition. Should he not receive proper clinical care, his condition is likely to worsen and increase the risk for suicide, and then a reference to references. 5.3. No evidence could be found to indicate that Mr. Pistorius has a history of abnormal aggression or explosive violence. Abnormal aggression and violence was never incorporated into his personality as borne out by both psychometric testing and collateral information. He does not display the personality characteristics of narcissism and or psychopathy that are mostly associated with men in abusive relationships and have been linked to rage-type murders in intimate relationships. Those who know him describe him as gentle, respectful, and conflict avoidant. The times when he did become angry were found to be suitable for the situation and context. His style of conflict resolution is to talk through the situation or remove himself from the situation. He also has the ability to self-reflect afterwards, mostly leading to feelings of guilt and an apology from him. His ability to regulate his effect is well developed. 5.4. There is evidence to indicate that Mr. Pistorius does have a history of feeling insecure and vulnerable, especially when he's without his prosthesis. He has also been exposed to crime directly and indirectly throughout his life. A reaction to a threatening situation comprises more than flight or fight. An appraisal takes place instantly, whereby the individual assesses firstly the intensity of the threat and then his position to cope with the threat. These appraisals are influenced by, amongst other things, previous experience. When Mr. Pistorius' appraisal of a situation is that he might be physically threatened, a fear response follows, which might seem extraordinary when viewed from the perspective of an able-bodied person, but normal in the context of a disabled person with his history. 5.5. No evidence could be found to indicate that Mr. Pistorius suffered from anxiety to the extent that it impaired his functioning prior to the incident in February 2014. He specifically does not meet criteria D for the DSM-5 for generalized anxiety disorder. Quote, the anxiety, worry, or physical symptoms cause clinically significant distress or impairment in social, occupational, or other important areas of functioning. That's also referred to in Annexure C. If his context is taken into account, his function was superior prior to the incident in February 2014. For somebody of his age, his achievements in both his occupation and the social sphere were enormous. The successful intimate relationship he craved and his inability to rehabilitate his relationship with his father being the only areas where he achieved less success. 5.6. There is evidence to indicate that Mr. Pistorius was genuine with his feelings towards Mrs. Steenkamp, and that they had a normal, loving relationship. He did become insecure and jealous at times, but this was normal for the specific situation. He would express his displeasure and irritation, but would try and sort it out later by talking with Ms. Steenkamp. Although the relationship was still young, there were no signs of abuse or coercion like those often found in these kinds of relationships, and then reference to previous works by experts. In his previous long-term relationship of 4 years, these aspects were also absent. And then the findings, which were previously read into the record, just as to his mental state. So the submission that we make, of course, there is no dispute about the mental state that is, with specific reference to Section 78, that's on record. And then as regards to the report is before the court, to be considered by the court, of course, in the context of all the evidence before the court. And there would be no cross-examination on behalf of the defense.
Thank you.
Thank you much.
Thank you. Mr. Neld, any addition?
My pleasure, good, my lady. We have a similar argument. The argument is, as indicated earlier, we accept the finding as far as the mental incapacity is concerned. factual findings and what it's based on would be still open for argument. We also indicate that we're not asking the court to call the witness, but it's a court's witness, and that would always be an avenue open to the court to do. Well, Lady, may I then do the same, though, with the other psychiatric report,
Yes, yes,
where
yes.
we also did not read out
The full report, yes.
report in more particularity. I will then start reading that. We hereby certify and report as follows regarding the mental condition of Oscar Leonard Carl Pistorius, hereinafter called the accused, who is apparently 27 years old. The examination consisted of clinical interviews with the accused and observation of his general behavior. He was physically examined, special investigations, including blood tests, and that's a difficult yeah, that's very difficult. May I get some guidance from behind me how I should pronounce that word? Electroencephalogram, my lady. I don't apologize for not being able to do that.
Yes, can you repeat that, please?
Do you want me to repeat it, my lady?
Yes, please.
Electroencephalogram.
Thank you.
Please don't ask me to do it again.
Thank you.
The psychosocial report was compiled, psychometrics was done, and the psychological report was compiled. Documentation that was perused included a case docket and official court proceedings report, a medical record from Mill Park Hospital about treatment received during 2009, psychiatric report by Professor M. Foster, report by Dr. R.G. Holmes. Then B, psychiatric diagnosis at the time of the alleged offence according to DSM-5, none. Currently, the accused presents with an adjustment disorder with mixed anxiety and depressed mood that developed after the alleged incident. This has no bearing on paragraph C. Paragraph C reads, at the time of the alleged offences, the accused did not suffer from a mental disorder or a mental defect that affected his ability to distinguish between the rightful and wrongful nature of his deeds. A mental disorder or mental defect did not affect his ability to act in accordance with the said appreciation of the rightful or wrongful nature of his deeds.
Thank you very much. That exhibit, can you just put it on record? What exhibit is that?
This was RRR, my lady.
It's triple.
And that is the
psychiatrist report.
Psychiatrist report. But
And the other report, the psychologist report, I don't believe we put that on record. What exhibit is that?
my lady, may I? Will the court grant me 1 moment just to confirm this?
Yes. It's QQQ. I just want them to
I have a triple P for the psychiatrist report.
The psychiatrist.
And triple Q.
Hold on. The psychiatrist report is PPP.
PPP.
Thank you very much. And the psychologist report
Is QQQ.
Thank you very much.
That's good, please.
Thank you. Yes,
you.
Mr. Roo.
My lady, we have one witness. We just have the witness is available. Maybe we just have a 5-minute adjournment, no more.
We'll take a short adjournment.
It please my lady and learned assessors, the defence calls for the evidence of Professor Wayne Durman.
The witness may be sworn in, please.
Sir, please state your full name for the record.
I am Elton Wayne Durman.
Do you have any objection in taking the prescribed oath?
No, I do not.
Do you consider the prescribed oath to be binding on your conscience?
Yes, I do.
You then swear that the evidence about to give shall be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, so help me God.
So help me God.
The witness is sworn in, my lady.
Thank you very much. Professor, you may be seated if you so wish.
Thank you, my lady.
Thank you, my lady. Professor Durman has raised with me his objection to having any visual images of his testimony broadcast. I just raise this merely for purposes of it being in conformance with the court order.
Yes.
My lady, I've taken the liberty of placing, or we'll do so in a moment, placing before you the file which contains the curriculum vitae of Professor Durman. His evidence will be tendered as an expert witness. What is contained in this file is his curriculum vitae, which I've taken the liberty of marking ZZZ1, and then a report compiled by the witness to be marked ZZZ2, if the court so pleases.
Thank you very much. No visual images of this witness may be published in any form.
As the court pleases.
Yes. Thank you very much.
Might I then proceed?
Yes, you may
Thank you.
proceed.
Professor Durman, you've been handed a file which contains your curriculum vitae, which is comprised of some 53 pages. That is in the first section of the file. And then in addition thereto, a report compiled by you. Will you have sight of those documents and confirm the documents as I've indicated them?
Yes, these are my documents.
Very well. Professor, are you comfortable?
I am, sir.
Wonderful. Would you please tell the court what is your occupation?
My lady, as is contained in paragraph 1, I am a registered medical practitioner with the Health Professionals Council of South Africa, having been so registered since 1988. I practice as a sport and exercise medicine physician. I furnished this report intended to give evidence in the matter of the State versus Oscar Pistorius, with the express understanding that I do so in my personal, private and professional capacity as a medical practitioner and not as a representative of any institution or organization that I may have been or am presently affiliated to.
Professor, with reference to the latter caption in paragraph 1 of your report, there appears to be a disclaimer, and it reads as follows, and I quote, "I furnish this report intended to give evidence in the matter of the State versus Oscar Pistorius with the express understanding that I do so in my personal, private and professional capacity as a medical practitioner and not as a representative of any institution or organization that I may have been or presently am affiliated to," unquote. What is the need for that disclaimer?
My lady, I felt the need to put that disclaimer in as I am currently or have been representative on many bodies. For example, this would include the University of Cape Town, the Sports Science Institute of South Africa, the International Paralympic Committee, and the SASCOC, or South African Sports Confederation and Olympic Committee. I do want to make it quite clear, and that is why I put that disclaimer in, that I am not speaking on behalf of any of the bodies that I have been associated or am, and that what I am doing here by standing up and giving evidence is in my own private and professional capacity.
Now, as a medical doctor, what are your qualifications and do you hold any fellowships?
As is contained in paragraph 2, I am qualified with an MB-CHB degree from the University of Pretoria in 1986. I furthermore graduated from the University of Cape Town with a BSc Medicine Honours in Sports Science with distinction in 1988. I also graduated with a PhD in Physiology from the University of Cape Town in 1993. I have been a Fellow of the American College of Sports Medicine, and I am a Fellow of the International Federation of Sports Medicine.
Professor, would you please explain to the court where you currently practice your occupation?
In paragraph 3 I read, "At present, I occupy the position of Professor of Sport and Exercise Medicine in the Department of Human Biology at the University of Cape Town. I am also a co-director of the Clinical Sport and Exercise Medicine Research Group, which incorporates the IOC Research Center for Injury Prevention and Protection of the Health of the Athlete and the FIFA Medical Center of Excellence. Both these aforementioned institutions are based at the Sports Science Institute of South Africa in Newlands in the Western Cape."
By virtue of your title as professor, do you perform any academic functions?
Yes, my lady. In the performance of my functions as Professor of Sport and Exercise Medicine at UCT, I have lectured and assumed responsibility for the academic and clinical training of sport and exercise physicians. And I have been instrumental, together with various of my colleagues, in bringing about the creation of a new speciality in medicine in South Africa, namely the discipline of sport and exercise medicine.
Professor, are you responsible for any publications and have you presented any academic studies? If so, will you please name them?
As per paragraph 5, I co-lead a research program and have in my career published over 100 peer-reviewed papers in international and local journals and have authored or co-authored 25 book chapters, as well as presented over 200 presentations at international and local conferences as invited speaker. The particularity of the publications that I have made are presented and dealt with in my curriculum vitae.
Professor, with particular reference to what is contained in paragraph 6 of your report, please tell the court what your areas of specialty are.
My lady, my research areas include the prevention of illness and injury in athletes with impairment or disability, and neuroscience as it pertains to the stress response, as well as chronic disease prevention.
Professor, would you please proceed to read into the record the contents of paragraph 7?
I have authored or co-authored 6 original research papers in international journals on medical aspects of Paralympic athletes and other athletes with impairment or disability. I have also been an invited speaker on a number of occasions at the VISTA, which is the Paralympic Medicine and Science World Conference, in 2011 and 2013, having spoken on the topic of the medical challenges of the travelling Paralympic athlete. In 2013, I was invited to give a seminal lecture on stump socket interface problems in athletes with amputation.
Sir, with reference to the contents of paragraph 7, would you please explain for the court's benefit your reference to the description of stump socket interface problems?
My lady, when anybody has an amputation and we have a residual part of the limb left, that needs to be made into a interface or a continuation with a prosthesis, and that area where we have a artificial joint which is formed is called a stump-socket interface. And why I make special reference to the stump-socket interface is that we are creating a joint where there is not meant to be a joint in the body actually formed. So with the stump fitting into the socket, we have an unusual, a medically unusual area where there are abnormal forces that are going through that area. It is also contained in a tightly concealed artificial environment where there is moisture, there are excessive forces, there's friction and rubbing, and this is one of the main areas of problems with athletes who have amputations and are wearing prostheses. And this is the reason why this is a specialized area in this field of medicine, and this is why there's the necessity for certain such lectures to take place to my colleagues.
Professor, as per the contents of paragraph 7, you've also made reference to the medical challenges of traveling Paralympic athletes. What is so unique with those difficulties that you've described?
My lady, international travel is a very difficult part of any international athlete's profession. It involves a lot of stress of traveling. It involves many hours sitting in an aeroplane or on buses or in cars. And it involves the physiological difficulties of crossing many time zones, either eastwards or westwards. And that places a physiological challenge on any athlete, and it's a difficult part. Can you imagine now if we have athletes who are impaired in certain ways, some confined to using wheelchairs, other athletes with movement problems, how this adds an added layer of complexity to the challenge of traveling for long periods of time and across many time zones. And that is why I make special reference to this.
Professor, you've testified about these medical challenges that present with athletes afflicted with disability. Having regard to what is stated at paragraph 8 of your report, please explain to the court the nature of the impairments and or disabilities which are encountered with members of the Paralympic team.
My lady, as per paragraph 8, the range of impairments or disabilities presented by members of any Paralympic team would include 6 different categories. The first would be athletes with limb deficiency, including amputation. Then there would be athletes with visual impairment. There would be athletes with movement disorders. The example I give is cerebral palsy. There would be athletes with intellectual impairment. There would be athletes with spinal cord injuries. And finally, there would be the category of les autres, or the others.
Now, what is contained at paragraph F in paragraph 8, the concept or description of les autres, the others. What exactly does that mean?
My lady, this means a separate category for all the other types of disabilities. For example, les autres would contain or include athletes of very short stature, commonly called dwarfism, and those athletes would fit into this category.
Professor, paragraph 9 reads as follows, and I quote, "In and during 2012, I was appointed to the Medical Commission of the International Paralympic Committee to lead a research team as a medical expert with reference to a longitudinal injury and illness surveillance study until the Rio Paralympic Games in 2016, unquote. Please would you explain the meaning of the concept longitudinal injury and illness?
My lady, we do not know what happens to athletes with disability or impairment over the entire course of their career. And when an athlete has an impairment or disability, things change in the body. For example, an athlete who has a spinal cord injury, who is a wheelchair user, uses their arms not only as propulsion of getting around every day, but they use their arms for their sport as well. For example, an athlete who might be a wheelchair basketball athlete. We find in our studies that there is an extraordinary number of injuries in the upper limb of athletes, for example, who are wheelchair users or athletes who are amputees. But it has never been determined what the long-term consequences of that. We wouldn't want an athlete to get to the age of 50, 60 or 65 years old and find out because of their sporting career and the excessive use of their arms as weight-bearing limbs that they are now unable to propel themselves in their activities of everyday living. We also don't know what happens with illnesses over a long period of time. So these studies, of which I am advising the International Paralympic Committee, have started. They started with a large study in London that has been published in the British Journal of Sport and Exercise Medicine. We followed that up in Sochi at the Winter Paralympic Games, and this is now ongoing into the future to follow this cohort of athletes up to see what happens in the whole entire length of their careers and further.
Professor, would you kindly read aloud the contents of paragraph 10?
Paragraph 10 reads, with reference to my research in neurophysiology, my thesis for my PhD dealt with aspects of the sympathetic nervous system and its modulation through the ingestion of beta blockers. I have co-authored 4 international publications on the neurophysiology of the stress response. 2 of the aforementioned publications were published in 2010 and 2013 respectively, both in the Journal of Applied Psychophysiology and Biofeedback, and the other publication in 2011 appeared in the Journal of Applied Cognitive Psychology. A further publication took place in 2012 in the International Journal of Stress Management. Furthermore, I have co-authored a further 16 publications which deal with long-term psychological stress and the role it plays in chronic disease. A full list of my publications can be found in my curriculum vitae.
Professor, having mentioned that your PhD was read with reference to the topic of sympathetic nervous system, would you kindly explain what exactly that means?
My lady, the body has certain automatic functions. Right now I'm standing before you speaking. My heart rate might be a little bit elevated. I'm moving around. My breathing is regulated. These are all automatic functions. And they are governed by an automatic nervous system, which has 2 components to it. There is the parasympathetic nervous system and the sympathetic nervous system. Now, the parasympathetic nervous system governs all the relaxation response in my body. Right now, I'm using more of the sympathetic nervous system. This is the nervous system that is regulating my heart rate. It's getting me ready to speak to you. It is increasing my heart rate and my blood pressure, and it's working on a system of stress hormones which is interacting with receptors in my body, and this is governing my real ability to actually perform right here and right now in an excited state. So my PhD was on that part of the nervous system, which is the sympathetic nervous system.
You have also made reference to the ingestion of beta blockers. What exactly does that mean?
My lady, when the body is under any form of stress and the sympathetic nervous system fires, there are neurotransmitters which come from my brain and go right through my body. The one that you would probably know is adrenaline or noradrenaline, and that interacts with certain receptors in my body. Those receptors are various different types, but some would be beta receptors, and that would govern my increase in heart rate, for example. Now, a medication that sits over the receptor and blocks my adrenaline interacting with it is called a beta blocker. And my interest in my PhD was to see if people can still become aroused and ready for exercise even if they are taking these medications called beta blockers.
Would you also explain the meaning of the concept neurophysiology of the stress response?
My lady, the stress response that I've spoken about from the sympathetic nervous system is all governed by our brain and certain areas within our brain. And a part of my research interest has been in the neurophysiology of how the brain governs that sympathetic response.
Now, apart from the many positions that you occupy, we know that also relates to your academic involvement with UCT. Do you also have a private practice?
Paragraph 11 reads, I also practice privately as a sport and exercise medicine physician, which practice is based at the Sports Science Institute of South Africa. I have practiced as such in excess of 20 years. This practice, which is shared with a number of colleagues, provides professional consulting services to provincial, national and international level athletes, as well as members of the public. Our practice has provided consulting services to members of the South African rugby, cricket, soccer, Commonwealth, Olympic and Paralympic teams.
Would you also read the contents of paragraph 12?
I have undergone the necessary training so as to equip me to perform the role of team physician in San Diego, California, and Orlando, Florida, in the United States of America. I am also a member of the international faculty which trains team physicians and advanced team physician courses in a number of countries throughout the world.
Now, from your report, it would appear as though you explain the role of the team physician, which is to be found on page 4 of your report. It appears in italics. Please explain the role of the team physician.
My lady, the team physician accompanies the athlete on any international travel and really looks after their health through this very intense rigor of competition and traveling. And the job of a team physician is to establish a patient-doctor relationship of trust so that they can be looked after and cared after in a holistic way during this period of rigor. And really this encompasses the well-being of the athlete, protection of the health of the athlete, and that really involves not only physical but the mental and emotional aspects of the athlete and the traveling athlete under the stress of competition as well.
Would you also have regard to what's contained in paragraph 13?
My lady, I have been the team physician to the South African national soccer team, and I have been the medical officer appointed for the 2010 FIFA World Cup, which was in Cape Town, at the Cape Town venue. In 2000, I was appointed as Chief Medical Officer for the South African team for the Sydney 2000 Olympic Games, and I was then reappointed as Chief Medical Officer for the South African team for the Athens 2004 Olympic Games. In 2008, I was appointed by the aforesaid body as Medical Officer for the South African Paralympic track and field team to the 2011 World Championships in Christchurch, New Zealand. In 2012, I was appointed Chief Medical Officer of the South African team to the London Paralympic Games.
Professor, have you received any awards in recognition of the contribution that you have made towards sport and exercise medicine? And in that regard, would you please consider the contents of paragraph 14?
My lady, I have been very fortunate in my career. I have received recognition in the form of certain awards. These, amongst others, include a Paul Harris Award from Rotary International for tangible community service for educating the public with regards to the concepts of disability. And in 2004, I was a recipient of the Excellence in Healthcare Award, both from the Minister of Health as well as the Health Professionals Council of South Africa.
Please also read the content of paragraph 15.
The relevance of my involvement in this matter, I believe, relates to my skill and experience within the sphere of sport and exercise medicine, the background of the research and understanding of physiology as it relates to the brain and body, and my expertise in the area of disabled individuals with particular reference to working with athletes who present with impairment or disability. Furthermore, and in this context, I have an intimate knowledge of my patient, Mr. Pistorius.
What then follows, Professor, is a heading which reads, History of my involvement with Oscar Pistorius. I'm going to ask you to explain in some detail what that involvement of yours is with our client. And I understand that you have summarized for the benefit of the court what is contained in paragraph 16 up until paragraph 23. Just that which is your knowledge and experience with our client. Is that correct?
Yes, sir.
Would you then kindly deal with those paragraphs 16 up to and including paragraph 23, Professor?
My lady, paragraph 16 reads, this report summarizes my knowledge and experience of Mr. Pistorius gained over the 6-year period I have known him for. I've had the benefit of getting to know him by virtue of periodic health assessments, direct observations of the patient during medical consultations, both formal and informal, as well as my observations of him within the close confines of us residing together in a team setting throughout the Beijing and London Paralympics and the Christchurch IPC World Championships. During the events outlined herein and above, it was necessary to accompany Mr. Pistorius and other athletes on various travels for significant periods of time. Over a number of years, I have observed him interacting with fellow athletes, people in positions of authority, and members of the public in general, as well as having observed him within the extremely stressful environment of competing at the highest level. Unlike in the case with the majority of athletes in the team, I have spent a significant amount of time with Mr. Pistorius in the anti-doping control environment, which occurs as an automatic process when an athlete has achieved medal status. The foregoing takes place so as to ensure that the athlete has competed free from the influence of prohibited substances. Doping control can take place both out of competition and during the competition. It is during these tests, which can last for periods between 2 and 4 hours, that I have also observed Mr. Pistorius. I have remained a treating physician to Mr. Pistorius outside of the team physician mandate, however remaining as sports physician, at local and national championship events, as well as for intervening periods at which time I've had the opportunity to communicate with him telephonically or via Skype, at times when either one or both of us were outside the borders of the Republic of South Africa. I have maintained contact with him even after the events of the 14th of February 2013. Paragraph 17 reads, "From my observations, Mr. Pistorius is a highly dedicated professional athlete who is disciplined and focused with reference to his sporting profession." With reference to paragraph 18, Mr. Pistorius has always been very vigilant and cautious not to consume any prohibited substances or derivatives thereof when being medicated for common illness or when consuming supplements. On various occasions in the past, he has obtained my prior approval as to his use of certain medications or supplements to ensure that same was not prohibited, particularly with reference to items which may appear on the list of prohibited substances, which is the World Anti-Doping Agency list, or commonly referred to as the WADA list. To my knowledge, he has never tested positive for any prohibited substances, despite him having undergone many such tests during his career. With reference to paragraph 19, from a medical perspective, Mr. Pistorius is prone to respiratory tract infections and is very sensitive to pollutants as he is quite allergic. Perhaps the most significant medical issues over the years have proven to relate to his stumps. Mr. Pistorius' stumps have at various times proven significantly and chronically problematic. Of particular relevance have been the stump socket interface problems, which have culminated in the peeling of skin, leading to secondary infection of soft tissue, exposed and raw soft tissue, and irritation and swelling of the nerves and vascular tissues in the stumps. These problems relate particularly to his left stump. With reference to paragraph 20, on a number of occasions during periodic health assessments, examination of Mr. Pistorius' stumps revealed a long thin stump where the heel pad had moved laterally to the original positioning. There was a variety of scar tissue and a very thin amount of soft tissue under the residual tibia. There were various very tender areas on palpation of the distal lower stumps. Furthermore, it is apparent that he is unable to bear full weight on the left stump without placing it at an angle whilst walking, and this gives him a leg length discrepancy, which means an imbalance, and that makes physical balance and walking difficult. With reference to paragraph 21, on one occasion, I was contacted over Skype by Mr. Pistorius when he was in Belgium and I was in Glasgow. When a very distressed Mr. Pistorius showed me over the Skype camera his clearly bleeding stumps, which were deprived of skin. At that time, he was attempting to qualify for the London Olympics. I arranged for him to see a physician in London and also instructed the team doctor to take special dressings and medications to Benin, which was the next destination at which he would compete. With respect to paragraph 22, my observations relating to aspects of Mr. Pistorius' interactions with myself is that he is an anxious individual. I have found him to be anxious during most interactions with myself and others within the Paralympic village and other environments particularly related to competition. He has a tremor of the hands. He also presents with a sleep disorder, a disorder for which I have previously had to medicate him.
Professor, before you turn the page, I'd like to refer you to page 184, document attached to your report. It is entitled Psychological Distress Profiles of Elite Athletes with Disabilities clinical use of the Kessler Psychological Distress Scale, in brackets K10. Do you have that document in front of you?
I do indeed, sir.
Professor, I note that the author, in conjunction with W. Dim, who I assume is yourself, is one S. Ferreira. Is that correct?
That is correct.
Would you kindly inform the court as to the significance of what is contained in this publication?
My lady, the publication that I hold in my hand is an abstract. It's a published abstract of a presentation that was presented at the 2011 Vista Medical Paralympic meeting, which was held in Bonn in Germany. This was a presentation by my colleague, Dr. Ferreira from the University of Stellenbosch, and myself. And the title was called Psychological Distress Profiles of Elite Athletes with Disabilities, Clinical Use of the Kessler Psychological Distress Scale. And very briefly, to explain this abstract of this study that we did, is there is an instrument called the Kessler Scale, which is a 10-question score, which is called, in its abbreviated form, the K10. And this makes a very nice clinical tool to use to actually rapidly to administer to the athletes and get an idea based on their responses, how they're feeling, how they're dealing with the stresses of competition. Now, we looked at this from a perspective of seeing if we could use the K10 score to identify changes in psychological distress, and I want to be quite specific what I mean by psychological distress. We are specifically looking at two things: markers of anxiety and markers of depression in the Kessler scale, and see how those change over time from pre-competition to after the competition. And we were also interested in looking at a control group to the athletes with disability, and the control group that we collected was another group of international level athletes competing at the Ironman triathlon. So our findings, and that is looking at the results of this particular study, was I'm going to be speaking about mean scores, and I'm going to explain how we got to these scores. The average score for the group of athletes with disability was 18.9 before competition, and that decreased after the competition to a score of 16.1. So the scores that we also obtained, the pre-scores, were 18.9, as I've pointed out, but compared to our control group of international athletes without disability, was 16.8. So we made two conclusions from the study. That, first of all, the markers of psychological distress, namely anxiety and depression, were higher in the athletes with disability compared to a matched control group who were able-bodied athletes. And also we found that anxiety and depression changes over the course of a competition, and that the K10 score is sensitive to pick up those changes.
That then, what is contained in more detail at page 184. My lady, I note that it is 11:15. Is this an opportune time to take the tea adjournment?
Yes, we'll take our tea adjournment.
all of the time. And then what happens is once they are all scored, then those scores are added, and that gives us a score of how significantly distressed the athlete is. Now, the three sheets that you have before you, one labeled 185 is Mr. Pistorius's K10, and this was done in the pre-competition phase of Beijing in 2008. Then we see 186, that was done in the pre-competition phase before the Christchurch Games. And then the one marked 187 was the post-competition phase, also in 2011 at the IPC World Championships. So the scores on these three sheets show a 28, a 24, and a 19. So what you can see from these, and I'm going to refer you to the last two, namely 186 and 187, was that the psychological distress markers go down after competition as we would expect. But I will also refer back to the abstract now, because we can see the reference of these three scores. And I look at the mean scoring of the entire group of athletes with disability and the control group. The mean score prior to competition is 18.9, and the two comparative scores here
Excuse me? Where is that? That means where are you reading now?
My lady, this was referring back to the abstract which was page 184.
Oh, okay.
And it is under the results section.
Thank you very much.
And those were the mean or the average scores that I had for the groups that I explained before competition and after competition, and the control group, which were athletes without disability who were international level athletes. So the reference scores there are 18.9 prior to competition, and you can see the score on 185 is 28. Then there is the next one, which is also prior to competition, which is 24. And then there is 19, which we would compare to the post-competition. The post-competition scores was 16.1, and we have Mr. Pistorius' score of 19. So all that this does is it does show that the psychological distress markers, as measured by the K10, are higher than the mean values that are recorded for the entire group of athletes.
Professor, to gain clarity from what you've just testified, with reference to the three individual results that you've referred to, you've testified that it suggests that the results prove higher than the average group. Is my understanding correct?
That's correct, compared to the average score.
Now, what significance do you attribute to these test results, particularly with reference to our client?
My lady, essentially what I use these tests in a clinical setting, which means I use the information to some end in a medical perspective. And I explained to you that my job is to look after the health and the well-being of the athlete that I'm looking after. So one of the ways, and please remember that I'm looking after not one athlete here, I'm looking after a whole group of athletes. I use this test as a very rapid 10-question test which can be easily filled in. I'll use the scores of those tests to watch the group of athletes and see who are, let's say if I'm traveling with a group of 30 athletes, who are the 5 athletes, let's say, that are having the highest scores, who would need most of my support. And we do that in a subtle way. For example, the support would be where I place myself to sit within the team confines at breakfast or at lunch or at dinner and find out how it's going. And that's the way that actually we would use these scores clinically to assist our patients or our athletes.
would you kindly read the contents of paragraph 23?
With reference to paragraph 23, I have also found Mr. Pistorius to be hypervigilant. I have observed this behavior, particularly with him rapidly looking around a room and scanning when we are in the dining hall setting, the team setting, and even during one-on-one consultations in my rooms.
Professor, you make reference to hypervigilance. Would you please explain what exactly is meant by the concept hypervigilance?
A lady being hypervigilant is a restlessness, it's a looking around, it is a scanning for potential threat, so with an end to move oneself out of harm's way.
And as I understand what is contained in paragraph 23, you've observed our client with such demeanor. Is that right?
That is correct, sir.
Professor, please read out paragraphs 24 and 25.
With reference to paragraph 24, he presents with a very exaggerated startle response, which I have observed a number of times at opening or closing ceremonies when the events were marked by fireworks. Whilst I have seen this exaggerated response in a number of the Paralympic athletes, Mr. Pistorius exhibits an excessive response which involves him covering his head and ears and cowering away until the noise ends.
And 25, Professor, if you would.
With reference to paragraph 25, the last communication I had with Mr. Pistorius prior to the incident on the 14th of February 2013 was a call I received from him on the 2nd of February 2013 when he phoned me as he was suffering from an upper respiratory tract infection and sinusitis. After asking him a number of questions related to his symptomatology, I advised him to go to the pharmacy so that I could send through a telephonic prescription. I then asked him how life had settled down after London, to which he responded that he was at that moment lying next to the most wonderful girl that he had met. He also told me that he could not wait for me to meet her and that she was going to now take him to the pharmacy to collect the medication on prescription from myself. Thereafter, and on the 10th of February 2013, I followed up with him as to his medical condition and his fitness to return to training.
Professor, we then see a heading, disability in the context of vulnerability. Would you kindly read what is contained in paragraph 26?
My lady, it is my experience that the levels of anxiety and fear and the startle response or the flight and fright response are increased in certain individuals who present with impairment or disability. The fight and flight response is defined as the sympathetic system, which promotes responses that prepare the body for strenuous physical activity in the face of emergency or stressful situations, such as a physical threat from an outside environment. This response is typically referred to as the flight or fright. Sorry, I correct myself, the fight or flight. Because the sympathetic system readies the body to fight against or flee from the threat.
Professor, would you kindly turn to page 24 of the report? And whilst you do so, I'm going to ask you to explain, perhaps more in layman's terms, what is to be understood with reference to the concept of fight and flight response. You may do so by having regard to page 24 and certain pages 26 that follow.
My lady, I read a short extract from a textbook, Human Physiology from Cells to Systems, the 4th edition. This is authored by Laura Lee Sherwood from the Department of Physiology, School of Medicine, West Virginia University. And I make reference to page 24, the last paragraph on page 24. It says, the sympathetic system promotes responses that prepare the body for strenuous physical activity in the face of emergency or stressful situations, such as a physical threat from the outside environment. This response is typically referred to as a fight or flight response because the sympathetic system, and the sympathetic system is that system that I explained to you before tea time, that readies the body to fight against or flee from threat. Think about the body resources needing in such circumstances. And I'm going to put this away now because I really want to explain what happens in lay terminology. So this is a primitive response. This is the flight and flight response, is the response that ourselves as primitive individuals, caveman times, really got us out of the way of a predator. So when we would get the scare from the predator, the body would go into a set of physiological responses that would prepare ourselves to move rapidly out of the way of that predator so that we could survive. So what kind of responses would those be? So the responses which come from the brain and trigger through the adrenaline flowing through the system is that I would now need to flee. I would need my heart rate to increase. I would need my blood pressure to pick up. I would need my muscles to liberate as many fuels as possible so that there are a number of reactions which make available fuels for the body to now run and flee away. I would also shut down blood supply to certain areas of the body that I might not need. So for example, when I'm fleeing, I don't need my digestion. I don't need to make urine. So blood flow to those organs would shut down. It would be diverted to the muscle, so I would be able to get away. I need to thermoregulate or dissipate heat properly because I don't want to get the heat increasing in my body. So for example, sweating would be facilitated. So that is why people sweat rapidly under those conditions. All the hairs stand up on end. Even the eye changes. The pupils of the eye dilate to allow in as much light as possible under those circumstances. Even the clotting factors of the body are changed in anticipation of actually having to stop bleeding in this fight with the predator. So this is, in a nutshell, this flight and fright and sympathetic response that all of us have.
Professor, in your opinion, does the nature or the severity of the impairment or disability presented with by a particular individual perhaps lead to what I will term to be an exaggerated startle response? Is that possible?
It is possible. We all have a flight and fright response, each and every one of us, but I have seen exaggerated flight and fright responses in some individuals, including individuals with disability.
Perhaps what didn't come across sufficiently clearly for me is just how the sympathetic nervous system governs the fight and flight response. Could you perhaps elaborate on that?
My lady, the sympathetic nervous system is the part of the nervous system that actually is in control of that whole flight and fright response. So it is from that area of the brain that we're going to get to in due course that actually runs through this whole system. that sympathetic nervous system which is governing this entire response.
Very well. And what role, if any, does the fight and flight response play vis-a-vis perhaps strenuous physical activity?
My lady, the flight and flight response is absolutely necessary for any kind of physical activity. We can't do competitive physical activity without that. So whereas we could go for a run or a jog or a walk as part of our physical activity, we still need that sympathetic response to guide us and to actually modulate our physiology to allow us to exercise. But if one was going to really sprint or have to move out of harm's way, we would need to get a really exaggerated response in order to allow us to do that.
Professor, we'll return to this aspect at some later stage during your evidence. I'd like you to proceed, however, by reading the contents of paragraph 27.
My lady, paragraph 27 reads, "Furthermore, such response would feature more prominently in certain individuals presenting with impairment or disabilities compared to individuals without impairment or disabilities. My experience in this regard relates to observations that I have made in the care and management of athletes with disability. It should be noted that I am prohibited from disclosing information which may lead to the identification of patients who have been and remain under my care and treatment. However, I have observed a significantly heightened startle or flight and fight response in situations where persons with features of disability, including mobility impairment, who have reacted to perceived danger and imminent threat of harm. I did not witness this exaggerated response to the same perceived threat and imminent fear of harm in non-disabled individuals who had experienced the exact same situation. In a limited number of individuals with disability who experienced the perceived threat, I was required to medically intervene and sedate the individuals concerned."
Professor, I note from the third paragraph, or the third sentence in paragraph 27, commencing with the words, "It should be noted that I am prohibited from disclosing information." It must be, with respect, self-apparent why it is that you are prohibited from raising such matters which may then lead to the identification of your patients. Could you perhaps place that in context with reference to your evidence here today as to perhaps furnish the Honourable Court with a clearer understanding of, in this context, what it is that you may not refer to, unless, of course, you are compelled by the court?
My lady, I witnessed an event that when I compiled my report, I was concerned that by speaking about this event, one would be able to identify a certain group of athletes, and I realized that I would need informed consent from the entire group of athletes in order to talk about this and explain this to you. So because I do not have consent, I can't speak about it unless, my lady, you feel that it is necessary to give me an order to speak about that event.
Professor, having regard to what is contained in paragraph 28, and I quote, "This exaggerated fight and flight response is also a feature of other, quote, non-athlete, unquote, individuals who present with impairment or disability, unquote. Now, having regard to that particular caption, can you tell the court whether, in fact, there is a difference between startle and fight or flight response?
Yes, my lady, when I refer to a startle is the stimulus that starts at the level of the brain the flight and fright response. So the startle response is the initial response that is usually to a auditory or a visual stimulus, and that is what Mr. Oldwage means by startle. And the flight and fright response is the response that I have explained to you this morning.
Professor, is it your evidence that persons who present with disability exhibit a heightened response because of such a disability? And of course, we understand that the nature of the impairment or the disability varies. But in the context of a person with a disability, is there a significant presentation in such a person with a startle response?
There can be, my lady, but there need not be. So there are some individuals with disability who do not have an exaggerated startle response, and there are indeed those that I have witnessed, both athletes and non-athletes, who do have that.
Very well, we move on to the next heading, which is titled Sources of Information. And before we deal with the next paragraph, I want to ask you the following questions. From your report, it appears that you deal with 2 communications received from persons who present with disabilities. Why is that relevant for purposes of your evidence?
Because, my lady, these are collateral sources of information, people that I have had communication with who really contribute to my existing understanding of this issue to do with flight and fright response in individuals with disability.
And you've mentioned that you've communicated with both these individuals. Is that correct?
Yes, I have, my lady.
Very well. Would you then read the contents as contained in paragraph 29?
My lady, paragraph 29 reads, in and during September 2012, I became acquainted with a certain Ms. Sue Kent at a polyclinic situated within the London Paralympic Village, where she was employed as a massage therapist. Mrs. Kent was born with a condition known as phocomelia. The latter condition came about as a result of her mother having ingested a medication called thalidomide during her pregnancy. And this has really resulted in Mrs. Kent having the following impairment. She does not have full arms. She has a very, very short rudimentary arm structure that comes from her shoulders, and her hand then follows, so her hands go up to about this level there. Those hands are somewhat functional but not fully functional, and she has lost the full function of the lower arms. However, not having the use of her arms did not prevent Ms. Kent from becoming a proficient massage therapist who utilizes her feet for such purposes. During my interactions with her, I made mention to her of my involvement with Mr. Pistorius. Following the London Paralympics, I continued communicating with Mrs. Kent with regard to academic discourse related to the role of exercise in disability.
Professor, whilst you've testified that you have indeed communicated with the two persons who forwarded these communications to you, might I inquire from you whether, with particular reference to Mrs. Kent, you've had any personal interaction with her, in the sense that you perhaps met her in person?
Well, besides the meeting with Mrs. Kent in London, I have met with her at the Sports Science Institute in Cape Town, and I've had numerous Skype conversations with Mrs. Kent.
Would you then, for contextual purposes, read out paragraph 30?
Paragraph 30 reads, on the 17th of February 2013, I received an electronic communication from Mrs. Kent regarding what had been published in the media concerning the events of 14th February 2014, insofar it related to Mr. Pistorius. I include in this report, at page 27 and 28, a copy of the email so received from her.
Professor, a correction perhaps at the third line of paragraph 30 should read 14 February 2013. Do you agree?
Yes, I apologize, Mr. Aldrich.
Wonderful. Now, I refer you to the document at page 27 and 28 of your report. That appears to be the email that you have made mention of, correct?
That is correct.
Would you kindly read the contents of this particular email, pages 27 and 28, into the record?
My lady, I read, Dear Wayne, I hope that you are well. I am writing with regard to Oscar. Please excuse me if you have already thought about this. In my dealings with English coaches, etc., of Paralympic sports people, I have become aware that the truth is easily hidden by the young disabled person from themselves and from others in order to get on in life. The acceptance of the brave face is often the easiest option for all concerned in order to achieve results. You may dismiss my concerns for justice, put me in the fan or nut category, but I feel I have to write to you on this matter. As a disabled woman who has over the years come under attack in many different situations, I am amazed at myself and my automatic responses. Having read Oscar fired his gun through a door, I am concerned that people without disability will not understand that the flight or fright response in people with a disability may be more highly developed. I can find not clinical tests on this to support the statement, but have not looked in detail. If Oscar did not know who was behind the...
I haven't objected, but I'm sitting thinking, how would the court listen to an email sent by a person in London to our expert witness, giving him advice about her life and about conclusions she's drawn? That is just hearsay. I know that the hearsay is admissible when an expert witness gives evidence, but this is just going too far. I just don't see how this is relevant. So I understand hearsay, we allow that, but now we're reading a person explaining what happened to her, how she dealt with it. How can it be relevant to this particular instance? And we allow that in court, lady. It's just, it's inadmissible hearsay even for an expert to relate that to the court.
Thank you. Yes, Mr. Aldrich.
My lady, with respect to Mr. Nell's submission, firstly, I note that he makes the submission that I haven't objected. And then he provides some discourse as to the content of these, particularly this email, not being relevant. And at the conclusion of his submission, it would appear to me that he suggests that what is contained in this particular electronic communication amounts to hearsay evidence. I take exception to the submission by Mr. Nell, and perhaps I must assume in the circumstances that he objects to the reception of what he terms to be hearsay evidence. Now, for Mr. Nell's benefit, I'm going to deal with this in a little bit more detail and explain to my lady and learned assessors why the content of these emails do not constitute hearsay evidence. We'll begin right at the beginning by having regard to exactly what hearsay evidence is. As we know, there's been an addition to our law. The rigidity that we used to encounter with hearsay evidence has been relaxed by the provisions of Section 3, subsection 1 of the General Law Amendment Act 88, in fact 45 of 1988, my lady. But that's not my argument. My argument is that this is not hearsay evidence. And I find support for my submission by having regard to the decided case. We have copies for the court. Let me take those copies out. Just give me where's my document? To the matter of, and we will hand up copies of the, no, not the law of evidence. I've included, my lady, for the court's benefit, a copy of the relevant legislation that I have referred to as well. But I'm specifically relying on the matter of Lorna Dawn Investments, Proprietary Limited versus the Minister van Landbou, 1977, Volume 3, South African Law Reports at 618 rather, in the Transvaal Provincial Division, as it then was. My lady, in this matter, and I might simply explain the facts of this particular matter and how it finds application to the present scenario that we are faced with. The facts of this matter are simply the following. During a trial of a civil nature, there was an objection raised by the plaintiff who had land expropriated, and there was evidence tendered during that trial of a valuer who came to give evidence concerning the values that he had put to certain portions of land, and one can go into a lot more detail, it's not necessary, but he spoke about the different types of agricultural land, grazing, irrigated lands, and so forth. And principally the objection raised to the valuer's evidence was that it constituted hearsay evidence by virtue of the fact that the valuer found it fit and proper to gain information from surrounding landowners so as to gauge and arrive at a valuation of the land which was the subject matter of expropriation and which in turn became the subject matter of these civil proceedings. Now, the facts of that particular matter must, to a certain extent, with respect, be akin to what we have with the evidence of the current witness before court. They being that the professor has testified that he has had regard to the communication sent to him, but certainly not with reference to the truth of what is contained in these particular communications. That's not the purpose of his evidence with reference to these communications. Now, if one speaks to what is hearsay evidence, it is and as subsequently adapted by the new legislation, verbal or written evidence, the probative value of which is dependent upon the credibility of a witness other than the witness giving evidence. And of course, this is what goes to the heart of my submission. What must be part and parcel as to what falls for deliberation in arriving at a determination whether the evidence is relevant might be a consideration as to whether the evidence is being tendered so as to prove the truth of this particular communication. And that is not the professor's evidence. My lady, at page 4 of Lorna Dawn, I quote from a caption in this judgment which referred to the matter of Rex versus Miller, 1939, AD 106, at page 119, and I quote, "Statements made by non-witnesses are not always hearsay. Whether or not they are hearsay depends upon the purpose for which they are tendered as evidence. If they are tendered for their testimonial value, in brackets, i.e. as evidence of the truth of what they assert, close brackets, they are hearsay and are excluded because their truth depends upon the credit of the asserter."
Where exactly are you? Is it
At page 4, my lady.
Page 4. Okay. Have you got it? Is that there's no English subtitles on page 4.
Page 4, my lady, if I might be of some assistance.
I think it's page
It is
5. It looks like it's page 5, isn't it?
Page 4 of the Lorna Dawn.
We've got the Lorna Dawn.
Judgment.
Yes. You were reading R versus Miller,
I beg your pardon,
1930.
my lady.
R versus Miller, 1930.
Indeed.
At page 119.
Indeed.
That's page 5.
I apologize. It's the way I've numbered it on my document. My lady, might I then continue?
Yes, please
I'm
do.
indebted. There, I'll start over. If they are tendered for their testimonial value, i.e. as evidence of the truth of what they assert, they are hearsay and are excluded because their truth depends upon the credit of the asserter, which can be tested only by his appearance in the witness box. If, on the other hand, they are tendered for their circumstantial value, to prove something other than the truth of what is asserted, then they are admissible if what they are tendered to prove is relevant to the inquiry, unquote. My lady, before I deal with any other aspects of this judgment, what comes to the fore and must be apparent is that if this evidence is tendered not to assert the truthfulness of what is contained in this particular communication, or perhaps if you deem it evidence at the end of the day, then the position is simply that it is not hearsay evidence. However, what Mr. Nell did was to submit at the end of his submission that this would not even prove to be relevant to these proceedings. And in that regard, if my lady would turn to the very next page, and I quote from line 3. Telkens, wanneer getuienis aangebied word van mededelings gemaak deur persone wat nie self getuig in die saak nie, en daar teen sulke getuienis beswaar gemaak word, moet die hof die aard van die getuienis oorweeg in die samehang van die saak as geheel en tot 'n beslissing kom of die getuienis objektief gesproke relevant is tot enige van die geskilpunte in die saak op 'n grondslag anders as dat die inhoud daarvan die waarheid is. As die antwoord op hierdie ondersoek bevestigend is, dan is die getuienis toelaatbaar vir die besondere doel wat dit relevant maak, afgesien daarvan of dit die waarheid is of nie. En die blote feit dat dit terselfdertyd op 'n ander grondslag ook ter sake sou wees, indien dit as die waarheid beskou word, kan dit nie ontoelaatbaar maak nie, unquote. And that's the crux of my argument. So,
You'd have to repeat that in English, please.
I'll do my level best, my lady. So what, my lady, what this in essence means is the following. If its relevance, that particular communication, is established separate from an inquiry as to its truthfulness, then it is proved to be admissible. Now, I want to compare these communications to perhaps collateral sources of information, because essentially that is what it will prove to be. And we see on many occasions that expert reports, particularly those of psychiatrists, psychologists and the like, contain references to collateral sources consulted during their preparation of a report which they then submit to court. And there's no difficulty with that. The end result of all of this must be that once the relevance of it is established, without having to even go into the question as to its truthfulness, then it proves to be admissible. Now, I repeat, these communications are not tendered in evidence for purposes of establishing the truthfulness of the events described in a particular communication, which is the very first one of Mrs. Kent that we have dealt with. My lady, with respect, that is the legal position, albeit, and it doesn't really affect matters such as these, or proceedings such as these, albeit that this is a civil matter. There is nonetheless an onus on the person who presents this evidence to establish its relevance, because we know only evidence which is relevant at the end of the day is admissible. I submit with respect that the relevance of this particular communication has already been established, and it will even prove more established if I'm given an opportunity to conclude the evidence in chief of the professor, and I'll make the submission why, my lady, that is important. I'm not seeking, and I want to be very clear, not seeking to invoke the provisions of section 3, subsection 1, subparagraph C of the General Law Amendment Act 45 of 1988. However, this is my submission, my lady. If it should be found, with respect, that your ladyship's ruling on this, if it is an objection, that this information constitutes hearsay evidence, then in the alternative, I will ask that we address this particular issue at the conclusion of Professor Derman's evidence, and I'll explain my submission as follows. When one has regard to the provisions of section 3, subsection 1, subparagraph C, it's established that a number of considerations which prove interactive in that context will be addressed not only by the evidence in chief which I propose to lead on this particular matter, but also in cross-examination. And I want to make my point very clear. One of the aspects that falls for consideration with reference to section 3, subsection 1, subparagraph C, is the nature of the evidence. 2, the probative value of the evidence. 3, the reason why this particular individual, who is the so-called reporter of the hearsay evidence, is not before court to give that evidence, can then be explored in full. To some extent, I believe that Mr. Nell's objection is premature, because once the professor has had an opportunity to explain how these communications are not only significant, but find application to his assessment and ultimately that which he's here to give evidence about, it will become clear why I say the 2 communications in question do not constitute hearsay evidence. But again, at the risk of repetition, if your ladyship finds that it does, I will then ask with respect that we address the provisions of section 3 of the General Law Amendment Act so as to allow for the reception of this evidence, because it is and will prove to be in the interests of justice. A final word and submission, perhaps, as to why I suggest that this particular communication is not hearsay evidence, is simply to be found in this submission. My lady, when you hear the evidence of Professor Durman, it will not be along the lines of him having to rely on the truthfulness of the communications that he had received, but because it finds support in his assessment by virtue of his qualifications, knowledge, and experience, that it is of a supplementary nature, and that's why he viewed it as important. My lady, in conclusion, my submission is that this is not hearsay evidence for all of the reasons that I've advanced before you. Those are my submissions, unless you wish to hear me on any particular aspect.
Thank you very much, Mr. Aldrich. Yes, Mr. Nell.
May it please the court, my lady. I've now heard that I'd never made an objection. When I said I haven't objected earlier. I've now heard that Mr. Aldrich takes exception to my objection, which I find very strange, because he's obviously prepared and expected a objection in this regard. My lady, then I've summarized what Mr. Aldrich have argued, and I'll deal with it. It's not hearsay. It's hearsay, my lady. It's statements from a non-witness that we cannot cross-examine. On the test for hearsay, it's hearsay. He then said, but if it's not presented to prove the truth of it, then the court will allow the hearsay evidence. That's true. But, my lady, what I haven't heard, and I was ready to write it down, is, what is the purpose of it then? Then at the end, he said, the purpose may be to support, to supplement, and to support the professor's findings. Now, if that is so, it's the truth. The court will never allow something that is not presented for the truth of it to supplement anything. So, my lady, I was waiting. I've been waiting, saying, if it's not presented for the truth, what then? What is it presented for? What is it presented for? Nothing came to the fore, except, my lady, at the end. The professor will not rely on the truth of what's in these 2 emails. Those will only be used as a supplement, to supplement these findings. Now, you cannot supplement the finding with something that's not true. So, in fact, it's presented for the truth of it. My lady, now I look at, I've now read it. If one reads the email, the paragraph where we stopped it. Because, my lady, to deal with this in a vacuum and not deal with what we have is an incorrect way of going about my objection. My objection is what in this email that is presented for other purpose than that being the truth. Nothing, my lady. I've watched disabled men, friends, throughout their lives interacting in a way so people misinterpret their fears and anger. Now, that's somebody walking the streets that have seen that. It's not an expert that sent that to a person. How can that ever be admissible? And how can it ever be relevant? How can it ever have any value? Then there's a further paragraph we'll get to. Still at 50, my fight and flight are way quicker than others. Now, why would you present that if nobody can test it? My lady, where Mr. Aldrich is, with the utmost respect, wrong is when you allow hearsay evidence through expert witnesses is where they have established fact by talking to people close to the accused, for example. But those people will be available. This person is not available. And this person describes what happens to herself, not the accused. It's not relevant to him. By including it in here, by using it to supplement his evidence later, that is then made relevant. My lady, it's not that. I say that with the utmost respect. It is hearsay evidence because the basic rule for hearsay evidence is it's evidence of a non-witness. Statements by a non-witness that cannot be tested. I cannot see, my lady, and I say with the utmost respect, my argument is that the court has not been convinced that it's presented for another reason than for the truth of it. Then the third aspect. Let's allow it. Let's just allow it and we'll discuss the probative value of this later. No, lady, that's always a way of dealing with these kind of things. But we're dealing here with an expert. A person that's presenting himself as an expert, that should not happen in his evidence. There should be a different threshold for experts. They shouldn't have things that are not admissible. And that should be decided now. My lady, to say, let's allow it and we'll discuss the fact if it's relevant or not at the end of the case cannot in this instance be accepted. It's either relevant now, it's either relevant to supplement or not. And unfortunately, my lady, that should be dealt with right now. Now, I haven't had as much time as Mr. Aldrich to prepare and read the case law, but I've quickly perused it. And I don't think there's anything in this case that's against my argument, except he could perhaps say that people's say-so about the value of a farm could be admissible in certain circumstances. But, my lady, to say that somebody says so about her fight and flight responses and what she's seen and friends over years as the same thing, that is with the utmost respect far-fetched, my lady. My argument is, my lady, this is hearsay. This particular aspect of this evidence should not be admissible. As the court pleases.
Thank you very much, Mr. Nel. We take our lunch hour now and come back at 2.
As a group, please.
Court will adjourn.
Rise and vote, my love.
The defense has sought to introduce certain evidence which counsel for the state has objected to. The basis of the objection is twofold. One, that it is hearsay evidence and therefore inadmissible. And two, that it is in any event irrelevant and for that reason inadmissible. Counsel for the defense has argued that the piece of evidence sought to be introduced is neither hearsay nor irrelevant. But before I go to the argument of counsel for the defense, I need to state that to determine this issue properly, it is necessary to scrutinize the nature of this evidence. The evidence concerned is to be found on pages 27 to 30 of an expert report compiled by Professor Wayne Damon. Professor Damon is currently in the witness box giving evidence on behalf of the defense. The evidence consists of two emails from two individuals who appear to have physical disabilities similar to those of the accused in this matter. Counsel for the defense submitted that the piece of evidence objected to was not hearsay, as the two emails were not tendered to establish the truth of the contents. He also further argued that the courts usually accept experts' reports, such as those of psychologists who have used different sources to compile their reports and make findings. It is so that courts usually accept the sources that are consulted by experts will not come to court and therefore cannot be cross-examined. The distinguishing feature between those instances and the present case is that the sources consulted by experts such as psychologists, probation officers, and other experts who compile pre-sentencing reports give light about personal circumstances of the accused. In the present case, the sources, that is the two individuals already referred to above, refer to their own circumstances. The circumstances of these two people cannot be relevant in this case. Counsel for the defense referred to the matter of the matter of Lorna Dawn Investments Pty Limited versus Minister Van Landbouw 1977, Volume 3, SA 618, capital T in bracket. I am of the view that this case, that is the case of Lorna Dawn, does not assist the defense in this argument, and I shall read a portion of an extract in the case that was referred to by defense counsel on page 5 of page 10. The judge in this matter, that is in the Lorna Dawn investment matter, quoted Watermeyer in R versus Miller 1939 AD 106, page 119. No, I rephrase, it's got to be in brackets, no, in quotation marks first, and then ... If, on the other hand, they are tended for their circumstantial value to prove something other than the truth of what is asserted, then they are admissible if what, and I want to emphasize this, if what they are tended to prove is relevant to the inquiry, close quote. Defense counsel's argument seems to have overlooked that condition, that the evidence will only be admissible, I quote, if what is tended to prove, what it is tended to prove is relevant to the inquiry, close quote. Defense counsel has not stated why the evidence is relevant, well, at least not in a manner that could persuade me. Instead, he submitted that should this court find that the evidence is hearsay, then it should be admitted under the exception rule, and the court should allow counsel to argue its probative value later. I think such an exercise would be fruitless. I'm not even going to entertain it for the reasons that I've already said. The evidence is not relevant. Counsel for the state correctly argued that the purpose for which the evidence is tendered is strange. I agree. One cannot use the evidence to support and supplement the report and still claim that the emails are not used to establish the truth of the contents. For the above reasons, the objection by counsel for the state is sustained. My finding is that the two emails from pages 27 to 30 by Professor Demon of Professor Demon's report are hearsay evidence and irrelevant. They are therefore not admissible. In addition, I order that the portion of the email on page 27, which has already been read into the record, be expunged from the record.
As the court pleases.
As the court pleases. I'm going to raise that other speak last. Might I then continue, my lady?
Yes, please do.
Professor Derman, I refer you to paragraph 33 of your report. Would you please read that paragraph into the record?
Yes, my lady, in paragraph 33, I state I am of the view that there is truth in the claim that individuals with disabilities fall victim to attack and abuse on a daily basis. I have been present at least 2 incidents where attacks were launched against persons with disabilities. In one such situation, I was on a train together with an athlete in a wheelchair, returning to the Olympic Village after an outing when drunken youths chose to taunt and ridicule the athlete. On another occasion, I was in a park in Germany during a festival when a colleague with a single amputation was physically manhandled so as to allow the abuser to gain easy access to an exit path.
Could we continue with paragraph 34, Professor?
The aforementioned unfortunate observations are referred to and confirmed as being regular occurrences which disabled persons are confronted with in scientific literature. A recent meta-analysis commissioned by the World Health Organization, Department of Violence and Injury Prevention and Disability aimed to measure the incidence of violence against adults with disability, copies of which are included herein as pages 31 to 60. The findings of this study confirm that adults with disabilities are at a higher risk of violent attacks against them compared with adults without disability. Furthermore, the more severe the impairment, the greater the risk of violence being perpetrated against them. The non-specific impairments, which is the category that Mr. Pistorius would fall into, has an odds ratio of 1.31, which means that this group would be at a 31% increased risk of attack compared to the non-disabled population. So, my lady, I draw your attention to this publication, which is on pages 31 to 60. And this is the WHO study. This is a meta-analysis. A meta-analysis is a study of many other different studies. And under the findings, I read in the last 3 sentences, pooled crude's odd ratios for the risk of violence in disabled compared with non-disabled individuals were 1.5 for all studies combined. That means, my lady, 50% higher risk. 1.31 for people with non-specific impairment, and then 1.6 for people with intellectual impairments, and 3.86 for those with mental illness. The interpretation of those figures is that adults with disabilities are at a higher risk of violence than are non-disabled adults. And those with mental illnesses, the article concludes, would be particularly vulnerable.
Professor, we begin to deal with paragraphs 35 and 36.
My lady, as in paragraph 35, a further study, this time commissioned by the United States Department of Justice, recorded the statistics of crime against persons with disabilities in the years 2009 to 2012, and this was published in 2014. The study found that in the year 2012, the age-adjusted rate of simple assault against people with disabilities was 38 per 1,000 of the population, which was more than double the rate for persons without disabilities, which is 16 per 1,000 of the population. In 2012, persons with ambulatory disabilities, the rate was 30 per 1,000, had a higher rate of falling victim to violent attacks than persons presenting with other types of disabilities. In this instance, the comparison was hearing or visual disabilities. These studies were published in a document entitled Crime Against Persons with Disabilities, 2009 to 2012 Statistical Tables by the United States Department of Justice and authored by Eric Harrell, PhD, a copy of which is included herein and numbered as pages 61 to 84. My lady, I will just read an extract on page 64. Which really just reiterates findings that are reported in 2012. The age-adjusted rate of violent victimization for persons with disability is 60 per 1,000, which is nearly 3 times the rate amongst persons without disabilities, which is 22 to 1,000 people without disabilities. And then in the top bullet in the right-hand column, in 2012, the age-adjusted rate of simple assault against persons with disabilities is 38 per 1,000, was more than twice that for persons without disabilities at 16 per 1,000 of the population.
If we may continue at paragraph 36, Professor.
My lady, paragraph 36 reads, the aforementioned findings highlighted the need for governmental organizations to take preventative steps. Indeed, the Crown Prosecution Service in the United Kingdom introduced Section 146 of the Criminal Justice Act of 2003 to cater for an enhanced understanding of disability hate crimes in the British legal system. In this regard, the Crown Prosecution Service produced a publication entitled Disability Hate Crime, Guidance on the Distinction Between Vulnerability and Hostility in the Context Against Crimes Committed Against Disabled People. A copy of this report is included herein and marked pages 85 to 105. So, my lady, this is the document that the Crown Prosecution Service had. And I'm going to just draw your attention to a paragraph on page 87 of this report, and it deals with this concept of vulnerability. And it says, a disabled person is not vulnerable or an easy target per se. And I think that this is very important. So by being disabled does not necessarily make one vulnerable. It is the particular situation in which they may find themselves and which is then exploited that makes them vulnerable to be targeted for some types of criminal offences. And a very good example is used. That is, for example, just because somebody is a wheelchair user does not make them vulnerable or an easy target for fraud, for example. But it may, however, make them an easier option for somebody looking to steal a handbag in the street.
Can we deal with paragraph 37?
Furthermore, it is a concern that since the advent of the Paralympic Games in London in 2012, an event that was intended to raise positive awareness of disability, attacks on individuals with disability have increased. In fact, a recent survey found that nearly 1 in 4 disabled individuals living in London has suffered some form of hostile or threatening behavior or has been physically assaulted since the Paralympics. In this regard, I include here too, marked pages 106 to 109, copies of an article published in the Independent newspaper dated the 29th of August 2013, which highlights the incidence of attacks on disabled individuals a year after the London Paralympic Games. My lady, that is on page 106 to 108. And I'm not going to read anything in particular in this particular publication. It is there for your information.
Yes, the question then must arise as to why, since the Paralympics were held, attacks against persons with disabilities increased, given that the Paralympics was intended to highlight the plight of people with disabilities. Can you comment?
My lady, it's a very, very complex issue. It's not an easy issue to understand why that has happened, and I won't claim to understand it fully. But what is of interest to me is that one of the slogans and the ways that the Paralympic Games of London were billed and promoted is the caption, "We are the superhumans." And one of the possibilities is that people can tend to now put themselves against the superhumans. Let's see how superhuman you might actually be. So, although that there is no proof of this factor, that is one of the considerations that is being spoken about and taken into account to understand why this increased crime against people with disabilities has increased since the Paralympic Games.
Professor, we are now going to return to the evidence concerning the fight and flight response. And in doing so, I'm going to ask you to deal with the contents of paragraph 38.
My lady, the fight and flight response is perhaps one of the most researched and documented physiological responses that occur in the human body. This response details the physiological reactions that allow the human in early times to escape the clutches of a predator. In more modern times, this phenomena is recorded to have occurred, for example, in events such as we all have heard of a mother picking up a car to save a child, or in the instance I give you here, as a mother fighting off a dangerous polar bear to save her children. Now, these are not necessarily just urban legends. I include here too, marked page 110, a copy of an article extracted from the CBS News website documenting this above incident of the mother and the polar bear. This finds application to the present matter simply by virtue of Mr. Pistorius having confronted perceived danger in very adverse circumstances.
Professor, can you explain for the benefit of the court why you say that such reported events, such as a mother fighting off a polar bear to save her children, is relevant to the current proceedings?
Well, my lady, clearly a polar bear is a very dangerous animal, and one would not necessarily go into a fight with a polar bear because of the danger that it represents. However, under certain circumstances, in this instance, the danger of having her children being harmed by a dangerous animal, her responses were to confront that danger and put everything at risk to try and save her children from the dangerous animal.
Professor, can we deal with paragraph 39?
My lady, in the 1920s, researchers determined that certain types and certain regions of the hypothalamus, which is the ancient midbrain, are critical for the flight and fright response to an imminent threat. This classic fight or flight response to a perceived threat is a reflexive phenomenon of the nervous system.
I'm going to ask you, Professor, to explain the reflexive phenomenon. We can do so by having regard to a section of the brain, which we are going to put on the screens for the benefit of the court. You'll also, my lady, find a copy of this at page 111 of the report.
My lady, I would like to first answer the first part of Mr. Aldridge's question, which was about the reflexive phenomenon and the explanation of a reflexive phenomenon. A reflex is something that you don't have control over. It is something that happens, for example, a knee-jerk reflex. As you know, if a doctor hits the tendon below your knee, the reflex ensues. There are certain reflexes that happen in the central nervous system as well. Now, I would like to read paragraph 40 of my report, which says the area of the brain that activates the flight and fright response is called the amygdala. This structure, which is actually a group of structures, receives input from various of the senses. Those senses would be our visual, auditory, olfactory, and taste sense, and has inputs from the thinking or conscious, also called the cognitive part of the brain, called the neocortex. The amygdala is also the seat of emotion and memories associated with emotional content, including fear. I include here too a copy of an image of a section through the human brain, marked as page 111. This is what I'm going to be referring to. My lady, learned assessors, this is It's rather technical, and I apologize for this being rather technical. And please, if I move too fast, please stop me and tell me if I am moving too fast, because it is really important what I wish to explain. So on the brain in front of you, you see this as a cross-section from the brain. This person is, for example, facing the wall, and a slice has gone through the middle of my head, and that is the brain seen there. There are three parts to the brain that I wish to draw your attention to. This is the cerebral cortex, this large part. This is the part here under the skull. And that is our thinking, our conscious, our planning. All of those executive type of strategies are in that part of the brain. Then you get this area here in the middle called the midbrain, which have a number of separate structures in it. Those structures are called the midbrain nuclei. And then we get this part of the brain here, which goes down. This is called the brain stem. That goes into our spinal cord. And this part here is the cerebellum, which is the part right at the back here. So I'll draw your attention now to this part of the midbrain, going into the brain stem. And this is our most primitive brain structure. This is our structure that controls all our involuntary actions. It controls our responses to deep-seated things that happened to us when we were children. All of those type of primitive reactions, subconscious reactions, happen at the level of this midbrain. Now, I draw your attention to that little, about a walnut-size nucleus over there. It's labeled the amygdala. And the amygdala is the area of the brain that is going to govern our flight and fright response. That physiologically is the area of the brain that rules that flight and fright response. And then we have this area, which looks like a curved C-shaped structure, and it is called the hippocampus. And that area of the brain goes and has connections with this neocortex, or the cerebral part of the brain, the thinking part of the brain. And that really also forms an important link between what is happening here in the thinking brain and the part of the brain that governs our subconscious or our automatic responses. So, three important areas: cerebral cortex, amygdala, the hippocampus, and the connection between what we call the hippocampal medial cortex connection, which I'm going to refer to in just a while.
Very well. Can we now deal with paragraph 41, Professor?
My lady, the conscious brain modulates the amygdala as well as the subconscious brain during emotions, arousal, and exercise. The conscious brain is in turn inhibited by the hippocampus, or that C-shaped structure that I spoke of. The projection of nerve tissue is called the hippocampal to prefrontal pathway, and the activity of this pathway is highly sensitive to stress. And I refer to a publication there, which is Godsell et al., which was published in 2013, a copy of which is included in my bundle, which is marked pages 112 to 128. Both the hippocampus, which is that area that I pointed out of the subconscious brain, and the prefrontal cortex, which is the conscious thinking brain that I showed, contain memory patterns that instantly activate when a person is in a situation that is perceived to be dangerous. The hippocampus, which is the subconscious brain, will inhibit the prefrontal cortex, or the conscious or thinking brain, thereby giving the amygdala free rein to maximize the flight and fright response. Research has found that individual differences in the structural integrity of the amygdala, of the subconscious brain, and prefrontal or conscious pathways were inversely correlated with trait anxiety, and I'm going to come back to this in just a moment when viewing fearful faces, and I'm going to speak about that in just a while. I would like to just deal with this article. It is the one by Godsell, and it is over pages 112 to 127. The purpose of including this particular article is to really, it's a review article, and it really speaks about these pathways that I am describing to you. If you have a look at, on page 114, there is a picture of the human brain. And if you look at that area marked B, in a diagrammatic fashion, those pathways have been drawn in there showing the hippocampal, prefrontal cortex, and amygdala connections. And what this article speaks about is the existence of these pathways in both animals and human beings. And if one reads on page 118, 1/3 of the way down the right-hand column, I just really want to show the relevance of this. They show together, these findings show that the hippocampus prefrontal regions are engaged in situations that involve emotional regulation related to fear. So that is all that I am really going to refer to in this particular publication, to show that this is an area which has been established. It is an area that is still actively researched, and it is an area which is very, very interesting in the development of neuroscience.
Professor, by having regard to the contents of paragraph 42, will you please explain how the response by the amygdala is triggered?
I'm sorry, Mr. Aldwage, I'd prefer to finish 41 first.
Very well.
My lady, these pathways that I have described also show a link with anxiety. These pathways are inversely correlated with trait anxiety when viewing fearful faces. And I'm going to refer you to this article, which is on page 129 to 133, where they did a study looking at this amygdala activation in 20 psychiatrically healthy subjects, and they measured certain anxiety measures with these people, and they found that there is higher pathway strength with lower anxiety. So the lower your anxiety, the higher the pathway strength. The higher the anxiety, the opposite occurs. The lower the pathway strength, the more the amygdala is unfettered or uninterrupted in its flight and flight response. This research suggests that people with high trait anxiety have less cortical or conscious brain modulation ability over their amygdala during fearful situations. So I proceed with paragraph 42. The initial reflexive physiological reaction to trigger the amygdala is called the startle, or it's also referred to as the fear-potentiated startle. This response can be elicited in the face of any threatening stimulus. The stimulus is usually auditory, as in a sound, or visual, as in something that somebody sees. I'm going to refer to an article by Christian Gillen entitled fear-potentiated startle relationship to the level of state trait anxiety in healthy subjects, published in Biological Psychiatry in 1993. A copy of the aforementioned publication is included here too, marked pages 134 to 142. And then I am also going to be referring to a second article by Christian Gillen, which is published in 2002, called Startle Reactivity and Anxiety Disorders, Aversive Conditioning, Context, Neurobiology. And this was published in Biological Psychiatry 2002. A copy of this is included here too, marked pages 143 to 160. And these two articles make reference to the fact that the startle reflex is potentiated during experimentally induced anxiety. And this is called fear-potentiated startle. It is also increased in persons who present with anxiety. It is further held that evidence is presented showing that anxious patients are overly sensitive to threatening contexts. So I understand that that is a lot of medical jargon, so I'm going to try and explain this rather slowly. So I would like, my lady, to explain to yourself and the assessors what this fear-potentiated startle, how it is measured. So essentially, individuals who are undergoing these experiments are placed in front of a computer, and they have certain electrodes that are placed on them. There's one over the eyelids. There are electrodes all over the other parts of the body which measure the muscle reaction, and there are electrodes also placed behind, so one can measure the distance whereby one moves if you get a startle from the experimental condition. Now what happens is that they do various type of startle to measure how one responds physiologically. So how quickly the eyes shut, or how forcefully the eyes shut, or how quickly the person recoils. And then there are various different experiments that are done. For example, one is just with earphones on, where you're sitting and looking at the screen, and all of a sudden they will have a loud auditory stimulus that actually gives you that startle response. There's another form of this experiment where they take an electrical apparatus and attach it to part of the body, where they give you a shock as well. And you don't know where that shock's coming from. So they put you into a state of fear and then give you that auditory stimulus, and they see how your expectation of fear amplifies the startle response. And they do this in all different types of environments. They do this in the setting of fearful faces, neutral faces, all various types, light environments, dark environments, and all different types of settings. And the two experiments that I have taken to show you are relevant to this matter. So I'm going to read an extract from the first abstract, which is on page 134 in the middle of the paragraph. Again, the title of this is Fear-Potentiated Startle Relationship to the Level of State Trait Anxiety in Healthy Subjects. Before the experiment began, each subject's fear of shock was assessed with the state portion of the State Trait Anxiety Inventory, which is a tool that was designed by Spielberger. Fear-potentiated startle, but not baseline startle, differed in the low and high fear subjects. The magnitude of the fear-potentiated startle was larger in the high fear group as compared with the low fear group. So if I draw your attention to page 139, my lady, you will see there down the first column there are some bar graphs. They divided these subjects into those who were characterized as low fear and those characterized as high fear. Low fear was this group over here, where you see those bar graphs, and the high fear in those 3 bar graphs afterwards. And you can see by looking at, this is looking at the amplitude, which was the measure of the eye reaction and the startle response, that if you look at the, under the condition of no threat, which is the open bars, the low fear group had a much lower baseline startle than the high fear group. Then there is the black bar, which is baseline threat, and you see that the people now who were in the low fear group increased their startle response. The high fear group did not change, but what is really important here is that third striped bar, where it shows that when you get the actual shock that you have been anticipating, look at how the people who are low fear individuals behave differently to the high fear group, and they respond with a higher startle.
Professor, if I might assist, we will require you to deal with a certain caption at page 148, which also deals with this particular aspect.
Thank you, Mr. Aldridge. My lady, this is the second paper by Christian Grilland, and it is a review article really detailing all the aspects of this phenomenon that I am explaining to you. There were some really interesting parts of this particular article. I have highlighted an area on page 148, 1/3 of the way down the page, which reads, "In fact, children who are at a higher risk for anxiety disorders because of a parental history for these conditions exhibit greater baseline startle responses compared to low-risk children." And I read on page 149, 2/3 of the way down the page, patients who suffer from fear disorders such as simple phobias, not surprisingly, these patients exhibit exaggerated startle responses when confronted with their feared object. So the point, my lady, of these 2 papers is to really document and show you that these experiments have been done in the literature, which really shows the differences between people who are anxious and those that are non-anxious, or fearful and non-fearful. And that from a biological perspective, there is a difference.
Hence the finding, and I quote at paragraph 43, "Consequently, the fear-potentiated startle is known to be more pronounced in people who present with fear and or anxiety," unquote. Is that then the literature that supports that finding, Professor?
Yes, sir, it is.
My lady, I note that it is 3 o'clock. Before we adjourn, if it is a convenient time for that, I'm instructed to raise a particular aspect concerning the exhibits marked PPP and QQQ. It is a request that we will ask your ladyship to consider with reference to, and we've learned that consent has been granted for these 2 reports to be released into the public domain. My lady, I'm alive to the fact that we have dealt with the conclusions on the record. It is what it is out there. However, as for the balance of what is contained in those reports, particularly the report of Professor Scholz, a lot of very personal and intimate information is contained in those reports. and I have been instructed to request your ladyship to respectfully consider granting an order prohibiting the publication of the information other than the conclusions arrived at and which have been dealt with on record. There is, of course, my lady, some level of urgency given the fact that these reports have been
They're already out there
indeed
in the public, yes.
the extent to which publication has already taken place, I do not know. But we are acting cautiously, and hence this request that we make.
I can only prohibit something that has not happened yet. So we would have to say, as from this moment.
Indeed.
Yes. Anyone else wants to make a submission in that regard?
I've no submission in this regard.
Yes. I wish someone had alerted me to this earlier. I wish someone had alerted me to this earlier.
My lady, I was informed of this at the conclusion of the lunch break.
Yes. What is
We certainly had no knowledge up until that time.
This is my order as requested by Counsel for the Defense. It relates to Exhibit PPP and QQQ. I grant an order prohibiting publication of the contents of these exhibits apart from the findings that were put on record. Was it today, yesterday? It was today.
They were dealt with earlier, I believe it was on Monday, as well as today, my lady.
Yes. I'm aware that especially QQQ is already out there in the public. I would specifically ask the media people to be careful. If, as from this moment, there is publication, that will be contempt of court. What has been published before 3005 or 15005, 100 hours, is that we can't do anything about. What was published before then, we can't do anything about it. But as from this moment, publication of the contents of these reports, as I've already said, is prohibited.
As the court pleases, I'm indebted.
Yes. We shall resume tomorrow at 9:30 in the morning. Court will adjourn.
Carry on, Madam Court.